Good morning.
Please. So from where you have passed out your law?
Sir, from Campus Law Center, Delhi University.
LLB.
Yes, sir.
Thereafter you have done something?
Yes, sir. LLM.
LLM. From which institute?
Sir, same.
Same. In which year you have passed out your LLM?
Sir, 2022 last year.
What are you doing something else side by side or not?
No, sir. I have just passed my LLM and I would not practice because my university take the affidavit that we cannot practice during the continuance of LLM.
So let me know. Suppose you have been appointed as a sub-judge. In your case, in your court, some witness appeared but he is disrespectful. And litigant also disrespectful in the court. How you will deal with this situation as a judge?
Sir, I can reprimand the witness that he should behave in proper manner. If then also he is not behaving in proper manner, then I can basically adjourn the proceeding for that witness, or I can discard the witness in totality. And also,
under which provision of law you can discard the witness?
sir, if a witness is not behaving properly, then sir, I cannot recall the exact section, but I guess it is.
What is the judicial remedy a judge is having when somebody is not behaving properly, creating indiscipline?
Sir, he can reprimand the witness.
What do you mean by reprimand?
Basically, giving warning that he should behave in proper manner. Otherwise,
Suppose still he continue to not behaving properly.
sir, the judge can also initiate the contempt proceeding for that.
So can judge himself start criminal proceeding, or he has to refer somebody else?
No, sir, a judge cannot himself start the proceeding. He has to write basically to High Court or Supreme Court or through district judge. Basically, if I am a sub-judge, then I have to write my.
What do you mean by misjoinder and non-joinder of the parties?
Sir, a misjoinder of party where a party is who is not basically necessary or proper party, but he has been joined as a party in the suit. And non-joinder where a necessary or proper party is not joined in a suit, then it is called non-joinder.
What is the effect on the result of a suit when an improper party has been joined as a party?
Sir, if an improper party is joined, then the suit will still continue, but if a necessary party is not joined, then suit cannot be decided properly, so suit will either stay or it will be dismissed.
What is difference in rejection of the plaint and in returning of the plaint?
Sir, in rejection of the plaint, first of all, the rejection of plaint is a decree, so it can be appealed, and return of the plaint is an appealable order, so it can be appealed under Order 43. And secondly, sir, in rejection of plaint, the further in two cases, the party can basically apply for the further period to get basically those defects cured, and in return of plaint, basically the court sent the petitioner to some different court because the court has not jurisdiction. The party, in case of return of plaint, may apply for before the court as to on which court to go, and the court can also decide the date on which the court has to appear in proper court.
What is final report?
So final report is submitted under section 173 of the CRPC. When police basically completes investigation, it either decides to pursue the case or it decides to basically close the case. So in case the police decide to pursue the case, it is set the charge sheet. It is filed under 173 clause 2. And if it decide to close the case, it basically called the closure report, and police also it is also filed under.
What is the remedy of the complainant in case of closure final report?
Sir, the complainant can file the protest petition before the court.
What is doctrine of issue estoppel?
Sir, issue estoppel is basically a sort of res judicata. In the issue estoppel, basically an issue which had been decided by a court in a previous suit is basically the party is basically barred to plead that very issue in subsequent suit.
General law is that hearsay evidence is not admissible. Is there any exception to it?
Yes, sir.
What are those?
Sir, first of all, Section 6 of the Evidence Act which talks about res geste. If a event happens, okay,
That's a no. Read me.
section
Res gesta 1.
res geste 1, section 7 and 8 also an instance of res geste, they are also included. Then sir, admission by party and the section 32, that is time regulation, these are the exception of hearsay rule.
What is the value of the expert report? Evidentiary value of the expert report.
Sir, expert report is basically opinion of expert as to any matter which happened or as to any effect which basically is effect of any fact in issue. So in that case, the expert can give opinion in the matter of science, art.
Where there is difference in ocular evidence and medical evidence, which will prevail?
Sir, if the ocular evidence is entirely inconsistent with the medical report, and medical report is like DNA test or something which can be so
Suppose a witness says that the man has given me 10 blows of lathi, and in MLR there is only 2 blows, then which will prevail?
Sir, if there is inherent inconsistency between the medical report and the ocular evidence, then ocular evidence must be discarded.
What do you mean? What do you understand by the concept of a stock witness?
A stock witness is basically, sir, if a police is going to investigate somewhere or going to search or made some survey, then they basically choose the person from a bucket of person. They choose one of them as witness. A stock witness was in news when the NCB made the famous survey in case of Shah Rukh Khan's son. In that case, the issue of stock witness.
What is doctrine of frustration?
So doctrine of frustration is dealt under section 56 of Indian Contract Act. It basically says that if any event which is impossible to happen or any event which is impossible, then it can if any contract is made between two persons to do basically an impossible event, then it will be void. And if the event turns subsequently,
Elaborate doctrine of force majeure in concept with the COVID-19.
sir, in COVID-19, for example, the SEBI and RBI basically extended the guidelines for paying the debt. So in that case, if COVID-19 like situation happens, then there is financial crunch in everywhere. So in that case, the time can be extended. But sir, if this is something which is financial hardship, this cannot be termed in the impossibility as section 56 contemplates.
Okay, when is an offence under section 138 Negotiable Instrument Act said to be have occurred actually?
Sir,
at which stage?
Sir, if suppose I am a creditor, I have given loans to somebody and he paid that loan through check to me, and that I presented that check to the banker, and banker returned the check saying that this has been dishonored because there was insufficient fund in the bank account which has to give the money to me.
So only insufficient fund?
No, sir. Yes, sir.
Or there are more also?
Sir, as per my knowledge, only insufficient. And then I will give a notice to that person that I have presented check to the banker and it was dishonored, so you should pay to me within 6 months, I guess. And then if he refuses to pay or he failed to pay, then I can file a case under 138.
After end of?
After that, sir, I am not sure about the months.
What is privileged communication?
Sir, privileged communication is dealt under section 121 to 131 of the Evidence Act. It is basically communication between two parties, two persons which are so closely connected in we can say in a relationship where the communication by one person is need to be protected. For example, communication between husband and wife. If a communication between husband and wife is to be revealed, then the entire sanctity of the institution of marriage.
Can you tell me the difference between section 505 and 153A of IPC, because lot many FIRs are getting registered under these two sections these days?
Sir, as per my knowledge, 504 is basically
505.
505 basically talks about when somebody says something which can basically generate a sense of enmity between the various sections of the society. And
On the basis of?
On the basis of, sir, religion or anything that can be discriminated about caste, religion, these things. And 153A basically
Recently, it was very much in news in connection with matter. You remember?
Yes, sir. It was in case of hate speeches. It was there in the famous case of, I guess, Amish Devgan versus NCT of Delhi. The court made various
and very lately, 2, 3, 4 days, 5 days.
Sir, a new incident.
Yes, what about Manish Kashyap?
Yes, sir. Manish Kashyap is also put under sedation in Tamil Nadu jail for basically circulating a fake video which could basically.
What is the remedy where an offence is punishable by imprisonment up to 2 years? There is no discharge in someone's case. How you will get your client, a person discharged from there? How get out of this process?
Sir, in some cases, the discharge can be made in only one instance where the complainant is not present and the principal witness has not been examined. Then in only that case, discharge can be made. Otherwise, if the complainant is not present, then the effect will be acquittal.
Can accused be discharged after framing of charge if the witness is not present?
Sir, there is no framing of charge in some cases.
In every case,
What is the operational definition of a legal evidence?
Sir, as per section 3 of the Evidence Act, the evidence is of two types. One is oral evidence and second is documentary evidence. In case of oral evidence, the Evidence Act says that those statements which the court either allows to make before it or require it to be made. And the documentary evidence is basically a document which is presented before the court for its inspection.
Okay. Another thing, for want of witness, eyewitness, many criminal cases are being accused of moving free. They are discharged. They are not getting the punishment. What should be the remedy?
Sir, if the direct witness is not available, then case can be proved through circumstantial evidences. Section 5 to 55 of the Indian Evidence Act basically deal with those situations where circumstantial evidence can be inferred through various.
How to generate the circumstantial evidence?
The circumstantial evidence is basically generated through this surrounding circumstances or surrounding events that happen. Suppose a person kills A kills B and he ran away. Then his running away is also a relevant fact under section 6 of the Evidence Act. If he purchased a weapon before the killing, then the purchasing of weapon is also a relevant fact. So these are circumstantial evidence which can be corroborated in order to basically establish this guilt.
Yes, Mr. Suki.
What is your personal view regarding the Delhi Service Bill which is recently passed by the Lok Sabha and Rajya Sabha?
Sir, recently Supreme Court gave a verdict that the Delhi government would have the power to transfer and make posting in the service matters in and the government of NCT of Delhi. But the bill has been passed in Lok Sabha and Rajya Sabha also, which basically talks about that there will be a committee which will be headed by the Chief Minister of the Delhi and the Cabinet Secretary and the Principal Secretary Home Affairs will be the member of that committee, and this committee will look into the transfer posting thing of a service matter in NCT of Delhi. So, sir, as the law has been passed and it is basically passed to give a clarity over the judgment of the Supreme Court. It basically, in popular sense, it is believed that it is basically passed to nullify the order of the Supreme Court. But as the Home Minister in Lok Sabha said that Delhi has a special status, it is a union territory and it is basically directly run by the central government because there are almost all the high commissions are there in Delhi. So as per Home Minister, the government cannot be trusted. Delhi government cannot be trusted in transfer posting.
Last question, मुझे ये बताइए, what is the psychology of testimony?
Sir, in testimony, the judge basically sees that the eye movement of witness, that if he
true or false.
If he's basically making some eye gestures, or he's looking underconfident, or he's looking overconfident, or he's looking at her or his lawyer continuously. So in that cases, the judge can basically make mind that how much value to give to the evidence of that.
Last question. While writing the judgments, facts are important or reality is important?
Sir, as per my view, the facts are important because as being judge, we cannot go beyond the rules that has been framed
What
by the
about
constitution.
reality?
Sir, we can.
I want to have your comparative analysis. Reality is important or the fact is important while writing a judgment?
We can give some due weightage to the evidences based on reality, that we have certain knowledge, so we can give the value. We can give the weightage to the evidences which seems real to us, but we cannot ignore the fact and we cannot ignore the rules of evidence and CPC and CRC.
As I, in my view, you have good chance of your selection. But for two things, आप थोड़ा सा लैंग्वेज पर कमांड करिएगा कि जो स्टैमरिंग हो जाता है ना, बस ये आपकी कमी है. You have good knowledge of law. You have also command on the facts and general knowledge also. एक आप जो हेयर वगैरह ना कोम करके अच्छे से जाइएगा. If possible, अगर आपको कोई दिक्कत ना हो तो क्लीन से
नहीं सर, वो क्लीन से
वो ज़्यादा आपकी पर्सनैलिटी को अच्छी लगेगा. मेरा व्यू ये.
एग्जैक्टली. दूसरा, आप अपने आंसर को शॉर्ट रखिए. जो आपको पता तो है, आप पूरा एक्सप्लेन करने का इतना समय आपको नहीं मिलेगा. कीप योर आंसर वेरी शॉर्ट सो दैट इवन द एग्जामिनर, द इंटरव्यूअर इज इंटरेस्टेड इन दैट. लंबा आंसर टेक्स अवे द इंटरेस्ट.
When I said fact and perspective, and instead of going so long, you could have said that fact and reality are directly proportional to each other.
देखिए हमारा कोर्ट का सिस्टम ऐसा है कि हम रियलिटी तक पहुंचते ही नहीं हैं, हम तो फैक्ट बेस्ड होते हैं.
Bullet points are needed.